Testing witness mic 1, 2, 3, 4. Is it really hot? Testing member mic 1, 2, 3, 4. Testing, testing.
The Subcommittee on Financial Services and General Government will come to order. Good afternoon, everyone. And Chair Gensler, welcome back to the Subcommittee. My colleagues and I are looking forward to today's conversation with you. The nation's economy remains in a precarious position. The banking sector is in a state of unrest. Prices continue to be inflated due to excessive spending, and in the country's debt is on an unsustainable trajectory. Yet, this administration is proposing a budget that is more of the same. Unfortunately, the Securities and Exchange Commission is following suit. The fiscal year 2024 budget request for the SEC is $265 million above fiscal 23 enacted levels, which is a double-digit percentage increase. Now, some will say the SEC's budget is fully offset by transaction fees. I get that, but that's only part of the story, and it completely ignores how bloated our government has become. Simply put, the sheer size and magnitude of our government is too large, and the SEC's budget is a prime example. After years of funding increases, we have an SEC that is heavy-handed with enforcement and examinations, and one that doesn't think twice about proposing new regulations to completely rethink our markets. The blistering pace of the SEC rulemaking is a cause for concern. We'll talk about that today. And this isn't just coming from members of Congress. The SEC's own Office of Inspector General in the fall outlined that SEC division offices raise concerns about increased risks and difficulties managing resources and other mission-related work because of the increase in the SEC's rulemaking activities. Again, this is your own Office of Inspector General. This is critically important, especially when the SEC is wading into areas that are not within their expertise and constitutionally questionable, such as requiring public companies to report on greenhouse gas emissions while claiming private enterprises wouldn't be impacted. Unfortunately, these steps taken by the SEC are more examples of their attempt to shift shareholder and board member responsibilities to others that deter from the betterment of these companies. The trend is diminishing the authority of boards, continues to expand outward at the agency, and can be truly disruptive. Let's be clear. The SEC's mission is to protect investors, ensure fair markets, and to support capital formation. However, conspicuously absent from all actions taken by the SEC is that of capital formation. Why does this continue to be the case? Private markets flourish while public markets stagnate. Examinations, enforcements, and regulations are top of mind for many at the SEC, but serious and practical capital formation conversations seem to be missing. The SEC must concentrate on all three tenets of their mission, not some over the other. Additionally, I've mentioned in past hearings, data security as it pertains to the Consolidated Audit Trail, also known as CAT, remains a top concern, and I'm hopeful that too can be explored thoroughly in today's hearing. Chair Gensler, I look forward to discussing these issues and others with you today. And with that, I'll now recognize my good friend and colleague, the ranking member from Maryland, Mr. Hoyer, for his opening statement.
Thank the chairman very much. I'll turn this on. Thank the chairman very much for his comments and for his friendship. And while we will disagree from time to time, we hopefully are going to work towards what all of us believe to be the best interests of the United States of America and its people. As we discussed in last week's hearing, the unrest surrounding Silicon Valley Bank and others ought to remind us how important it is that our federal agencies receive the resources they need to safeguard and strengthen our economy. The recent bank failures were not simply a product of inflation. They came on the heels of a previous administration's effort to roll back many of the regulations we adopted after the 2008 financial crisis. That reckless course of action left our economy vulnerable to these types of failures. We need to ensure that critical safeguards and high standards are in place in order to protect consumers and prevent the type of instability that led to the financial crisis in 2008. Last week, Secretary Yellen made it clear that Congress must provide funding necessary for the Treasury Department and other agencies to work together to prevent this economic unease. The SEC plays a critical role in that mission. We oversee a number of regulatory commissions. The IRS, to make sure people pay their taxes that are fairly due. the Consumer Product Safety Commission to make sure the consumers are protected from corporations that they couldn't possibly oversee themselves. The SEC, which tries to keep the market a fair, open, and transparent growth factor in our economy. And the Election Assistance Commission, which tries to make sure that we have fair and transparent elections. From supporting cryptocurrency enforcement to promoting climate change disclosures, the SEC is also working to address other emerging challenges facing our economy. As a firm believer in the public's right to petition their government, I want to ensure that the SEC is also providing robust opportunity for public input into its proposals. Now more than ever, Mr. Chairman, we must maintain the integrity of our markets, protect investors and consumers, and promote greater accountability in the financial sector. We cannot let new shocks derail the economic momentum we've built in the last 2 years, especially at a time when Americans are facing rising costs. As an aside, this economy has created 12 million jobs in the last 24 months, more than any other administration in the history of our country. Is inflation too high? It is. Is inflation being high all over the world a reality? It is. But this economy is one of the more robust economies, if not the most robust economy in the world today. We cannot do that. We cannot achieve those ends without a fully funded, fully equipped SEC. We have a $100 trillion market, and we cannot oversee that market and make sure it's fair and that confidence it remains in the market's fairness if we do not have the sufficient number of people. That's why I believe we ought to execute on the President's budget proposal, which requests $2.436 billion for SEC, approximately, as you indicated, more than $200 million additional. It is paid for, of course, out of fees, but the people necessary to do that are absolutely essential. Like the rest of his budget, the funding is investment in America's economic future. Conversely, making cuts to the SEC and other agencies like it would only leave our economy more vulnerable to turmoil like what transpired in the Silicon Valley Bank. I think I'm over time, and I apologize for that, but I'm pleased to welcome Gary Gensler. For full disclosure, I've known Gary Gensler for probably 40 years, maybe more than that. His father was a good friend of mine, so I'm not totally objective when it comes to Mr. Gensler himself. I hope I'm totally objective as it relates to the SEC. I yield back.
Let the record reflect that he yielded back with 30 seconds remaining. Only kidding. Chair Gensler, it is, you have a very important job, and it is truly important for you to be here today, and for that we thank you. And with that, I'm going to recognize you for your opening statement. Your prepared remarks will be entered into the record.
I thank you so much, Chair Womack, Ranking Member Hoyer. A point of personal privilege, it is remarkable to be in front of Representative Hoyer, who was a good friend of my father's. I guess when I was a little kid, I would hear about Steny this and Steny that. That's where I'm going to end. But I thank you. It's really good to be in front of you and testify the first time before you. And members of the subcommittee, thank you for inviting me to testify on behalf on the SEC's fiscal 24 budget. I always have to say, as is customary, these are my own views, and I am not speaking on behalf of my fellow commissioners or SEC staff. That's a standard language. The SEC, what are we? Who are we? We're critical to the American public. For 90 years, the federal securities laws and our work to oversee them have played a crucial role in good times and in times of stress. And these laws benefit, as the chair said, investors on one side of the market, issuers, capital formation on the other, and then the markets in the middle. That's our three-part mission. But it's about those investors and the issuers on the other side, and then trying to ensure that the middle of the market is efficient, competitive, transparent, and yes, these times of stress remind us, resilient. The agency's clients are 330 million Americans, your constituents. who invest in their 401ks, IRAs, trade through brokerage apps, take out mortgages, auto loans, and the like. They're Americans accessing the capital markets to fund their businesses from small to large, their new ideas, their innovations, and the like. It's for the investing public and issuers that our staff must continue to drive efficiencies and protect for financial stability in what the ranking member said is a $100 trillion capital market. We've seen tremendous growth in this market. More people than ever are participating. Just two quick statistics. Just in the last 5 years, since 2017, the number of clients of investment advisors has grown 60% to 53 million, from just about 36 or 7 million. Another statistic, the actual transactions in our stock markets, equity markets, has doubled in the last number of years. Technology also rapidly transforming our markets from electronic trading to cloud, to artificial intelligence, to predictive data analytics. Just the dynamism of our markets is a great thing. It's sort of like important to our capital markets, and this shows the innovation itself of America. Further, we've seen the Wild West of the crypto markets, rife with non-compliance, where investors have put hard-earned assets at risk in a highly speculative asset class. Such growth and rapid change also means more possibility for wrongdoing, as the cop on the beat, and about a quarter of our workforce is enforcement, another quarter is examination, so fully half of our staff. It's also, we have to be funded enough to meet the match of bad actors. Thus, it makes sense that the SEC grow along with the expansion of these markets. So just to put some context on the funding to meet the scale of our mission, what we've had is, I'm pleased to support the 24 requests for $2.4 billion. We actually shrank in the years from 2016 to 2021, about 4% or so. And with this committee's help and the full Congress's help, just in 23, we've gotten back to about 2 or 3% more in headcount than we were 7 years ago. You authorized, or you, in your appropriations, 400 new positions in 2023. But those positions come on in the latter part of this year because we have to go out, recruit, hire all those folks. So full year 24, part of that is to fund those people for the full time. We're asking for 170 more positions. That's about 3% growth on where we are. As this committee considers the request, of course, we're deficit neutral. Appropriations are offset by a transaction fee. It's tiny. It's $8 per $1 million of trading, so it's very tiny. Nearly 2 years into this role, I'm grateful to work alongside the remarkable staff, fellow commissioners, to help maintain America's capital markets. I truly think the best in the world, but we want to keep it that way. I thank you. I yield back 22 seconds.
I thank the chairman. And we will begin our round of questions. And let me remind everyone, we're on the 5-minute rule. You guys got a timer in front of you. You know what you have. And we will acknowledge people, call on people in the order they were seated at the time the hearing started. We may have some other folks show up a little bit later. Mr. Chairman, at the SEC, enforcement actions, examinations, and regulations are at the forefront, supported by weekly, if not daily, actions by your agency. Unfortunately, one of the SEC's core tenets, capital formation, continues to be an afterthought or an outlier, as I said in my opening remarks. Chair Gensler, how do we ensure that public markets are thriving and that capital formation continues to be a priority at your organization?
It's very much a priority. It's a priority of the staff. As I said in my opening remarks, investors on one side, capital formation on the other side, whether it's small or large corporations, whether it's somebody tapping into the mortgage markets to get capital so they can buy a home or borrow for the auto markets. Every rule that we put out for public comment has an economic analysis, and as Congress has mandated, around efficiency, competition, and capital formations. So we benefit from the public's feedback, this committee's feedback on efficiency, competition, capital formation. So it's at the heart of what we do every day.
Would your Republican commissioners, would they be in agreement on that?
I think that they would agree that it's core to our three-part mission. I think they would agree that it's a congressional mandate, and I think that based upon public comment, we get feedback as to how we best promote investors on one hand, capital formation, and as I say, the markets in the middle.
Would they agree that it's an appropriate priority with the agency?
Well, again, I don't want to speak for them because I'm only allowed to speak for I agree it's an appropriate priority.
Would you be willing to testify alongside them and commit to doing that in the future?
I testify whenever Congress calls me.
Okay, I'll take that as a yes. The SEC budget requests $265 million in new funding, which is a double-digit percentage increase. However, over the last few years, regulations have been on the rise. If the SEC receives this increase, should we expect more of the same? Because how does burdensome reporting requirements and other disclosures, especially those related to the climate, possibly enhance capital formation and increase American taxpayer wealth?
We've put out to the public not only each of the rules, but also our unified agenda, these 50 or 55 projects that we have that are very public. We're not planning to add to that based upon this appropriation. This appropriation request is really about making sure we have the examiners, the cops on the beat. Over half of our staff is examination enforcement, and the increase of the 400 positions this current year and the 170 next year, the vast majority of those are in really 4 areas: examination, enforcement, the Division of Corporate Finance to review filings, and in our technology area.
Finally, I want to ask about what you're doing with the money that Congress already has, and this is more of a people question. The SEC is relying almost exclusively on an academic fellowship program for the leaders of some of your critical divisions. Is it true that at least 4 of the SEC's top 6 divisions are headed by directors that have long been in academics? And if so, why is that the case?
Yes, it is true. 4 of our divisions are run by extremely talented individuals that are willing to serve their country and partake in this great experiment called democracy, and to actually help us. The Division of Economic Risk and Analysis is an economist, a world-class economist from the University of Pennsylvania, and the other 3 divisions are run by really strong individuals that are committed to the same 3-part mission that Congress has laid out.
I understand that, but would it not be important for there to be an experience factor? Folks running these key divisions that have experience. And let me just quote from the Inspector General's report that I highlighted in my opening statement. It reads, and I quote, "Some reported an overall increase in attrition and difficulties hiring individuals with rulemaking experience. Managers reported relying on detailees, in some cases with little or no experience in rulemaking." So, and that's in your own IG report. So help me understand why this is the case and why we should not be expecting and demanding more experience.
One, the leadership are terrific. These individuals of all 6 divisions are really quite talented individuals and have lending their time and experience to the American public. 2, in terms of your question about attrition, we run about 6% attrition right now, which is consistent with many of the other agencies that you'll be reviewing in the federal workforce. And we've consistently also ranked as one of the best small to mid-sized agencies to work at by outside ranking services and surveys. So I'm really proud of the SEC staff. I'm proud to say that I'm part of it, these remarkable 4,600 people and their leadership of these divisions.
Thank you. And I've gone over my time. I'm going to yield to the ranking member.
Thank you. So we can complete the answer to that question now. He asked about that relying on detailees as opposed to, as I understand it, relying on the expertise of the principals involved as opposed to detailees who had been sent over and getting their advice. Did you want to comment on that before I ask?
I thank you. The individuals in our divisions, whether it's economists, whether it's lawyers in these various divisions, work for the SEC. And there's rule writing shops in each of these groups, talented individuals. And we don't have detailees from outside the SEC. There are people in the SEC. What we do is each of those units internally find the best people to work on these projects. And they form teams between the Office of General Counsel, the economists, and they look at the legal authorities, they look at the market data, they look at the economics, and they make their best staff recommendations. And of course, ultimately, it's the 5 commissioners, and we form a consensus and put things out to public comment.
Thank you. Let me ask you generally, because the chairman has made a point of the increase that has been requested. And you indicated that you have some 40% growth in the market that you're looking at. Congress provided 400 additional slots. You have not expanded to that, and you're still in that process. Can you discuss what limiting SEC funding would do for the fairness of markets and what the real-world impact would be to investors, including individual retirement accounts?
I thank you. I think the real-world nature is that it comes back to human nature. Human nature is such that most people in the markets are good faith, do things well, but there's still some bad actors. And so we examine nearly 40,000 different registrants on a basis, and we do about 3,000 examinations a year, so you can see the math. We're not examining all of the registrants on a regular basis. We bring 700 or 800 enforcement actions a year, but the markets are so vast. So in terms of real people's lives, it's protecting them against fraud. It's protecting them against Ponzi schemes and the like. And so that's really the bread and butter of this agency, and reviewing filings, whether it's a mutual fund filing or other filings.
So that given the expansion of the market and the expansion of the participants, which is, I say, analogous to the IRS, who has a lot more taxpayers and a lot more complex tax questions to resolve. If you do not get the personnel that you want, there will be a lack of oversight and a lack of enforcement.
Yes, let me give you another statistic that we get between 2,000 and 4,000 tips, complaints, and referral a month, 25 to 40,000 a year. And so our dedicated staff has to sort of sort through that, be responsive to the public, see what's there, and then where appropriate, follow the facts and the law and try to get money back to the public, through disgorgements and penalties and the like, if the facts and the law deem that to be appropriate. And so less dedicated lawyers and investigators and economists in an agency like ours means less protection for the public.
And if there's less protection for the public, would it be reasonable to conclude that the public would have less confidence in participating in growing the capital markets?
I think it is, and I think to the chair's question, it's about capital formation and investors, because investor protection means more people are confident in a market. It means people raising money and in essence, can raise money cheaper because there's less of a premium for, misdeeds in a market.
Thank you. I yield back.
Mr. Moldenar.
Thank you, Mr. Chairman. Mr. Gensler, thank you for being with us today. The Office of Inspector General, October 22 report. You're very familiar with that, I understand.
Yes, I am in the chair, and I just chatted about it.
Okay. And the concerns raised by managers from the SEC's various divisions about the increased risks and difficulties managing resources due to the aggressive rulemaking agenda at the SEC. Are you familiar with that concern?
I've read it, yes, sir.
Okay. And you have had 11 commission rulemaking, had to reopen public comment periods for 11 proposed rules. Is that true?
I think we've actually reopened more. What we do from time to time is we reopen if new items come up. Sometimes new economic information comes up, we might reopen. Sometimes we reopen for other reasons, and I think it's actually more than 11 that we've reopened.
But anyways, you've had a pretty aggressive rulemaking.
Well, actually, let me just put this in context. My predecessor, Chair Clayton, during his 4-year tenure, did 64 final rules. We've put out publicly that we're looking at this 50 to 55 projects. I could go back to my fellow Chair, Mary Jo White, Chair Shapiro. Chair Shapiro probably set the record. She had way more than either Chair Clayton or what we're looking at.
Well, in the report, it talks about the significant attrition rate with senior officers and attorneys being the highest percentage lost. Talks about data entry issues in 91% of the job postings reviewed. The inability to hire individuals with rulemaking experience, what the chairman had mentioned. Dependency on detailees with little or no experience in rulemaking, potentially leading to more errors in decision-making. Limited time available to research and analyze these rules and their effect on other rules. Increased odds of litigation against the federal government and taxpayers. The inability to complete other core mission-related work due to rulemaking teams borrowing staff from other areas. And these appear to be things that have really bled into the entirety of the day-to-day life at the SEC. And it seems to highlight the need for effective resource management and prioritization in achieving organizational goals. And when you think about your mission, and I know you think about that every day, accurate data entry is essential to ensure that the decisions are made and affect U.S. financial markets are based on reliable and accurate information. And it just appears from this review by the Office of Inspector General that there is a lot lacking there. And it really brings to, questions when you increase rulemaking activities, you don't have the staff capable of doing these things. The explosion of data entry errors, it really raises questions and confidence in your ability to lead the organization. And I'm just asking if this aggressive rulemaking agenda has placed a strain on your staff. Are you concerned that the quality of the work proposed in final rules is slipping?
Sir, I am quite confident in the staff. We're in a very tight labor market. We're in a very, you all know this, we're in a very tight labor market, and the attorneys and the economists and the other folks at the SEC are sought after. They're deeply sought after by law firms and outside folks, but our turnover is consistent with what other agencies have been, and I also would say that our rulemaking agenda is actually consistent with what Chair Clayton was doing and other chairs were doing earlier. But do we look at each of the data entry pieces that you said and each of the parts of the Inspector General's report? You betcha that we look at that, and we benefit from having a robust Inspector General and give us good advice.
Well, it seems like it's more of a review and talking about areas that are really lacking. And I'm just wondering, do other SEC divisions rely on data entry in their cost-benefit analysis?
We look at data, and we absolutely do. We do cost-benefit analysis, or what's technically called efficiency, competition, and capital formation analysis in each one of our rules.
Well, I just wonder if you have that many data entry issues in the job posting, reviewed those. It just creates a question of kind of the capabilities and how solid the efforts are.
If I might just say, we spend about $390 million a year on technology, and that's part of being in front of this committee. Is like we spend in a year what some large banks or investment advisors spend in a month. I mean, so we are trying diligently to make resources for cloud, for data security, for data analytics work within that part of our budget. And that's an important part as well, that we could do better if we had more dollars for technology.
Thank you, Mr. Chairman. I yield back.
Mr. Cartwright.
Thank you, Mr. Chairman. Chair Gensler, I was listening to Ranking Member Hoyer's questioning of you, and forgive us, there was some whispering up here. It's not true that he's actually your godfather, is it?
We're going to keep that one a little quiet, but
But seriously, I was listening to his questioning, and he was making some important points about confidence in the capital markets and how that flows from protection of the investors. Is that basically what you said?
absolutely. And I think it helps capital formation as well as investors, because confidence and trust underlies any financial system.
Part of protecting investors starts at the point of sale with the broker-dealers. Am I correct in that?
Yes.
So what we have is the Financial Industry Regulatory Authority, FINRA, that is charged with that, and people go to arbitration put together by FINRA. The SEC is tasked with conducting oversight of FINRA. Am I correct in that?
That's correct, sir.
And certainly ensuring that it acts in the public interest for the protection of investors and in furtherance of the purposes of the securities laws. That's obviously in the code. And if the SEC finds that FINRA has failed to protect investors, the SEC may add to or amend FINRA's rule book or compel changes. And you're aware of that, Chair Gensler.
Yes, we got those authorities way back in the 1930s.
Okay. FINRA has the problem of uncollected awards. You're familiar with that problem, I take it. Well,
At a general matter, I'm familiar with it.
right. It does, and in fact, the problem is that, well, it started in a 2000 report from nonpartisan GAO, and I do request unanimous consent to enter this report into the record, Mr. Chair.
Without objection.
Okay. In 2000, the GAO found that a large percent of arbitration awards from 1998 went entirely unpaid by broker-dealers, and that an additional amount were only partially paid. GAO at that time, in 2000, recommended that the self-regulatory organizations, quote, develop procedures addressing the problem of unpaid awards caused by failed broker-dealers. But a generation later, up to now, FINRA has not established any such procedures. In fact, FINRA's data show that nearly $200 million in awards went uncollected between 2012 and 2016. And even now, the latest information show that between 2017 and 21, $94 million in arbitration awards went uncollected. And so the question is, will the SEC become more active in investigating this problem and laying down the law with FINRA to make them actually make changes so that by definitions, these are meritorious claims brought by investors who were in some fashion fleeced by broker-dealers and didn't get their awards paid. Will you undertake to put the hammer down on FINRA, as you are charged to do in the statute, so that they change their procedures and end this injustice?
So our oversight of the FINRA, as you said, is a really important part of our capital markets. It's a self-regulatory organization that oversees and investigates and registers broker-dealers. And part of that is, of course, this matter that you've just raised through our examination function and our Division of Trading and Markets. And I know that they've already had discussions. We'll continue to highlight the importance of this, the importance that whether it's through arbitration or through the courts, that when somebody is awarded disgorgement and penalties and so forth, that they're paid. I would note that sometimes those broker-dealers are out of business. And so there's some of that that goes on too. But I couldn't concur with you more that it's important for the confidence of investors that if they're duly awarded something because of their
Well,
claim,
good.
that
We
they
agree
should.
then, Chair Gensler, and will you undertake to make that more of a priority with the SEC?
I think it already is a priority, but I will commit to you that I will check with the staff and make sure that they understand the importance of this issue.
Perfect, thank you. Yield back, Mr. Chairman.
Ms. Hinson.
Thank you, Mr. Chairman, and Mr. Ranking Member Hoyer. And thank you, Chair Gensler, for appearing before our committee today. Iowans care about accountability. They care about focus on mission, jurisdiction, and you already mentioned congressional mandate for the SEC in an earlier answer. And so I think, to put it bluntly, we've seen you sprint outside of your congressional jurisdiction, specifically when it comes to the climate disclosure rule. I see it as a true weaponization of the department, and Iowa farmers, Iowa businesses, Iowa workers see it that way too, and I think it's high time that you reel it in. That's what I'm here to tell you today on behalf of my constituents. And I dug into the place where you say in statutory authority that you're citing 10 different sections of the Exchange or Securities Act in your proposal. And so my first question to you today is, where in here specifically did Congress give you the statutory authority, the jurisdiction to enact this climate rule?
I thank you for asking it. So our remit, all the way back from the 1930s, is to ensure that investors get to decide based on full, fair, and truthful disclosure.
I'm asking you specifically about where your statutory authority is in Section 7, 10, 19A, 28 of the Securities Act, Sections 3B, 12, 13, 15, 23A, and 36 of the Exchange Act. Can you cite where it gives you the actual authority? Because I went through all these sections, and nowhere does it say climate, emissions, or greenhouse gas.
But what it does say is that a company, when it's offering securities and offering a sale of security to the public, that the public gets the description of the business, the material information, and that they can't mislead the public. And what's happening now is there's hundreds, if not well over 1,000 companies today in the markets that are putting out disclosures about climate risk. And there's investors that are relying on those disclosures. And all we're doing, we're not, with all respect, we are merit neutral. And that's an important part of our capital markets. We are
Well, I think
merit
Congress
neutral.
clearly needs to
We're
be-
trying to bring consistency and comparability to those disclosures.
Well, it's very clear that in these sections, it is not explicit as far as your lane is concerned there. And that's when I say it's time to reel it in. You need to be explicit about where your authority is. And I don't see that in these sections of code that you reference. And I'm also very concerned by the expansive reporting requirements for Scope 3, greenhouse gas emissions, the devastating impact that would have for Iowa farmers, because under this rule, you look at large corporations, they have teams of attorneys that can help them comply. Iowa farmers don't have that. So I'm very concerned about the precedent that's being set here with these policies and what you're asking for here. So can you give me some examples of where the commission has asked for this type of non-financial information to be disclosed in the past?
So our remit is just over the public companies, the 7,000 or 8,000 companies. It's not the farmers that you're referencing. So that's probably, we share that view. And what this is about is the disclosures that the public companies are making, and we put out a proposal about trying to bring consistency to that. We heard a lot of comments back. So-called Scope 3 disclosures that you reference is one of the handful, but important handful of areas where public comment, we got 15,000 comments, came to us. 49 different farm bureaus came to us.
Well, I understand
And
about
so
the public
I think
feedback,
that,
but
I
is there
think that
precedent for this? That's what I'm asking. Is there any point in time where you can cite anything precedent-wise where you've required this amount of disclosure?
it's just to bring consistency to the disclosure they're already making. But as it relates to this issue about, there's no intent or focus of the Securities and Exchange Commission to ask for disclosures from private sector farmers in Iowa or in any of your states.
Well, what I'm hearing here is that this is unprecedented in your answer because you're not mentioning anything precedented, and I do believe that the focus of your agency should be on fraud, detecting Ponzi schemes, not on enacting a climate agenda, which again, I believe exceeds your statutory authority here. Thank you, sir. I yield back.
Mr. Pocan.
Thank you, Mr. Chairman, Mr. Ranking Member. Thank you, Mr. Chair, for being with us. First off, just on a budget question, do you right now, with your current budget, have adequate resources to investigate emerging cryptocurrency issues?
We're stretched thin, sir. This is a field, it's small compared to our vast $100 trillion capital markets, but it's a field that has a significant amount of non-compliance in it without prejudging any one token or one platform. We've increased our resources there, but we could always use more.
Yeah, just with the volatility, I mean, talk about confidence in markets, I think this is one area I'm concerned when some in the Republican leadership have talked about a cut going back to 2022 levels, or this morning, Mr. Harris actually said pre-COVID levels going back even more years, what impact that could have when there are emerging issues that you're going to need resources for. So thank you for that answer. Also, we've been reminded recently very clearly why Congress passed strong banking regulations like the Dodd-Frank law and why it's a mistake in 2018 to roll back some of those protections. We can likely agree that mismanagement and greed on the part of the executives at Silicon Valley Bank led them to make some risky decisions that endangered their customers. I'm particularly concerned about Section 956 of Dodd-Frank, which required a number of financial regulators, including the SEC, to set guidelines around responsible compensation incentives for bank executives and even prohibit compensation structures that drive executives to engage in risky behavior that may gain their shareholders bigger profits, but also endanger the broader economy. So to you and the Commission's credit, the SEC is the only regulator that has even attempted to fulfill this requirement that was passed into law a dozen years ago, but the rulemaking was never finished. Chair Gensler, do you plan on tackling these reckless and greedy incentives by having the SEC pursue a rulemaking process on this long overdue requirement?
Yes.
Great. Glad to hear that. Because I think in talking about confidence in markets, this is something clearly front of mind for a lot of people. Let me talk to you a little bit about congressional insider training. I know that New York Times recently said 18% of lawmakers or their family members bought or sold financial assets over a 3-year span. And, again, for confidence in Congress, this isn't even in the markets. I know we have the 2012 Stock Act that allows members to buy and sell individual stocks, provided that they don't trade on inside information and disclose transactions over $1,000 within 45 days. There's been bills introduced to change that, to make it so that we can't buy individual stock. And I'll tell you, I'm not one of the millionaires around here, so I don't buy a lot of individual stock anyway, but I do get a lot of insider information almost on a weekly basis from companies and people that come in because of the access to people that talk to members of Congress. How does the SEC conduct oversight on congressional trading, and how is a determination made if they believe a member is violating the Stock Act, and how would you define insider information?
A lot of questions there, but we follow the facts and the law. And so insider information, material, non-public information that a company has that the public doesn't have. It's not yet disclosed in their press releases, their filings, and the like, is not meant to be traded upon by those insiders or people they share that information with, whether it's the broad public or a member of Congress. And so we just follow the facts and the law, and we keep it confidential if we have an investigation, as we would whether it's somebody in the broad public or, of course, a member of Congress.
In the minute I have left, just a quick question. I think a lot of us are concerned whether or not we're going to lift the debt ceiling and what could happen to markets. As someone who's watching markets and concerned about faith in markets, are you concerned? And if you're concerned, why, in case we don't lift the debt ceiling, what that could impact that could have?
Well, it would be historic, of course, and it would be, in terms of trust, we were talking about trust and confidence in capital markets. The capital markets themselves would take a real hit. I mean, we have the gold standard of capital markets around the globe, and part of that is at the base is the U.S. Treasury market. This $24 trillion, about a quarter of our capital markets, it's called risk-free, but you'd add a great deal of uncertainty, and it'd be, frankly, one heck of a shock to the capital markets.
Great. Thank you, Mr. Chair. I yield back.
Mr. Cloud.
Thank you, Chair, Ranking Member, and thank you, Chair, for being here today. I wanted to continue on with the line of questioning Ms. Henson and other colleagues have had. The Securities Act of 1933 and the Securities Exchange Act of 1934, I'm sure you're aware, defines what is your role and what the Commission's role is. You'd agree?
Yes, very important. It's also the 1940 Acts on investment advisors,
Right.
investment companies.
And of course, the job of the executive branch is to execute the laws, not create the laws. And we also have the Anti-Deficiency Act that ensures that federal employees don't use federal resources to do things that they are not authorized and appropriated to do. I brought them with me today, the Securities Exchange Act of 1933, and of course we have 1934 right here. Are you aware of how many times, of course, we want good governance? We're all concerned right now. When I talk to banks, they're really concerned about the ESG initiatives that are being forced. We want good governance, but you want to guess how many times climate appears in these documents?
I understand the question. It's about
It's
full,
zero.
fair, and truthful disclosure
It's
about
zero.
a business.
You know how many times the word social appears? It's also zero. Right now, the SEC is currently working on a rule that would require companies to report on the cost of climate change for their businesses above a certain threshold. It's been talked about scope 3, and you're saying that that's not going to hurt farmers, but the thing is when a business is trying to get a loan, but they can't get a loan until they report on the next person in the supply chain who has to report on the next person in the supply chain, it does get down to the farmers. And so, I'm really concerned about mission creep. And, it's really hard to see where the SEC and certainly you as chair would have any sort of authority to be enacting these things. And I would just keep in light of that the Democratic-led House last term passed H.R. 1187 to try to require the collection of this kind of information. It passed by one vote with a lot of wrangling from Democratic leadership. Speaker Pelosi at the time had to actually come down and vote herself to give them that one vote to pass, and it would mandate public companies disclose climate information. My point is it didn't pass. It wasn't taken up in the Senate, and therefore is not law, and therefore there is no authority to collect this kind of information. Are you aware of West Virginia versus EPA?
It's a Supreme Court case of last year. Yes, very so.
Right. There are a number of findings in that, but one of them, the court held that an administrative agency has no power to make decisions on major questions unless Congress clearly gave it such authority. And as Ms. Henson pointed out, you don't have clear authority. You may be trying to skew authority or find authorities in law somewhere to do it, but you do not have clear authority to implement climate-related data gathering on people participating in our markets. And it's very concerning, and I would just point out, we've watched bank failures happen, and a lot of it happened because regulators were asleep at the wheel. At the same time, we see unauthorized rulemaking going on, and it's very concerning. And I would point out to the chair's comments, you're asking for more employees to do your job, but then it seems like some are tasked doing something that you do not have the authority to do. And so, we're trying to provide efficient government. We want you to do your core functions. You're needed. No one's debating that. You need to have funding to do your core functions. But I'm concerned about the argument for plussing up employees when you have employees tasked doing stuff they have no authority to do. And it's placing a burden on the American people. And it's trying to enforce policy that has not passed Congress. And so could you speak to will you retask your employees? If you're asking for more employees, will you retask the ones you have working on these sorts of things to do what is they're actually authorized core functions.
So let me speak to the climate role and to the employees. On the employees, most of the staff we're asking for and the funding is about our core, and the growth is in exams, enforcement, technology, and disclosure review is the bulk. But in terms of the climate role, if I could, if you wish, it really is authorized by our statutes, and what we're doing is we're hearing from the public about where we potentially should look at economics, look at authority. We're aware of this Supreme Court case that you referenced, and we do everything we do within the authorities as interpreted by the courts, and that's an important.
I would remind you
that's an
that
important
the public opinion flows through the representatives of Congress, and then we tell you what the public are thinking, and then you go and do it. And I'm out of time, so I'll yield back to the chair.
Thank you.
Mr. Bishop.
Thank you very much, Mr. Chairman, and welcome, Mr. Gensler. And I'd like to follow up on that line of questioning. The environmental, social, and governance data that is up for disclosure and up for discussion today, is that consistent? Isn't that consistent with your mission to protect investors, to maintain fair, orderly, and efficient markets, and to facilitate capital markets? Is that data, would that data be beneficial to investors to have? Or would it be harmful to investors not to have it in your capacity as a regulator?
To answer your question and the other Representative Cloud's question, right now today, hundreds, if not over 1,000 companies are making such disclosures about climate risk. And so our role is not only to help bring consistency, but to make sure that folks aren't misleading the public about these disclosures, because investors, and we heard from 15,000 comments, thousands of investors wrote in and said, we currently use this information. We would benefit to ensure that it's at least consistent and not misleading. That helps capital formation. That helps investors, and it helps regardless of whether you're pro-green or pro, you want to invest against green.
So it's consistent with your obligation.
It's consistent with what Congress authorities and mission that we have.
Thank you. Chair Gensler, for purposes of cryptocurrency, you have the unique experience of chairing both the Commodities Future Trading Commission and the Securities Exchange Commission. It's my understanding that cryptocurrency and the underlying blockchain technology typically defy categorization as either a security or a commodity because, quite frankly, they are neither. You understand more than most people the interplay between both commissions and the extent of their jurisdictions. With that in mind, I'd like to hear your thoughts on the regulation of the cryptocurrency market, and in particular, how you ensure that consumers are protected from fraudulent and predatory activity. Can you elaborate on what you think the SEC's role is when it comes to regulating the crypto market? And can you also follow that up by saying whether the SEC has any plans to issue a rule clarifying how securities law applies to digital assets?
At its core, when Congress set up the SEC, it was about protecting the investing public and thus the capital formation on the other side with this disclosure. And it was about if somebody's raising money and the public is giving them money based on their efforts. The Supreme Court in 1946 actually defined it, and then Thurgood Marshall wrote it so beautifully a few decades later. It was Congress painted with a broad brush to protect the investing public when the investing public is basically investing or betting on a group of entrepreneurs. Now, crypto tokens, without prejudging any one of them, you can look almost on nearly most of them, I'm not going to say a number, and you can find a group of entrepreneurs with a Twitter site, with a website, with individuals, and I bet that most of you are not visited by decentralized, non-existent management. If you're going to get a meeting with somebody from crypto tokens, there's a human, there's a group of entrepreneurs, or they're paying a lobbyist, or they're paying a lawyer to meet with you. There's some, and the public is basically giving up their hard-earned dollars to invest in that token and that token entrepreneur should give them full, fair, and truthful disclosure. That's the core. So frankly, of the 10 or 12,000 tokens, there are very few that don't have a group of entrepreneurs in the middle that the public's counting on.
So
So those are securities, sir, under the securities law.
are you going to issue regulations?
The regulations actually already exist, sir. They're called the securities regulation. And so they're disclosure regulations for when somebody tries to raise money from the public. They're exchange, the storefronts in this business. The storefronts call themselves either crypto exchanges or crypto lending platforms. But those storefronts should come into compliance. And our goal is the investor protection and capital formation we've talked about earlier. But even in the crypto space, they should come into compliance and they should disaggregate. Right now, they're commingling with, it's rife with conflicts that they're taking investors' funds and trading against the investors. And they're saying, catch us if you can. That's the nature of this field right now. Or, excuse me, we're offshore. Try to find us if we're offshore. And I've been around finance for 40 plus years. And there's, by and large, most folks are trying to comply with the laws as Congress writes them and so forth. But this is a field that at its core is sort of, it's got a lot of non-compliance and it's with the anti-money laundering laws and not just the securities laws.
Mr. Chairman, would you indulge me one quick question?
Chair will indulge you. Mr. Bishop, only because your office is right across the street from mine. Yes.
Thank you, sir. We were approached, members of Congress were approached with the proposition that we needed to regulate it by people who are in that offshore area. I'm trying to understand how the regulation would have helped those people in that offshore area who now seem to be accused with wrongdoing.
Well, whether it's the Commodity Futures Trading Commission, which I was honored to chair, and I love that agency, or the Securities and Exchange Commission, both of us oversee parts of the market, and it is, if you're touching U.S. investors, selling these tokens to U.S. investors, then you come under either the securities laws or the laws over the Commodity Futures Trading Commission.
Mr. Carl.
Welcome, sir.
Thank you. Good to see you, sir.
You're doing a great job so far. You're staying above water. Let me read this to you, though, because I'm a little confused. Congresswoman Henson and Cloud almost took all my thunder, and I almost didn't have anything to ask you, so I'm scratching around here. But, you know, the primary purpose of the SEC is to enforce the law against market manipulation, easy for you to say. Its three-part mission is protect investors, maintain fair, orderly, and efficient markets, and facilitate capital formation. What in the world has that got to do with admissions? Before you answer that, I'm a little confused. Let me be a little sarcastic. I got a friend of mine in the coffee business. If I want to know how all these 7,000 companies, what kind of coffee they use, can I get a question put on there to ask what kind of coffee they use so I can give it back to my coffee producer? Doesn't sound fair to me. So why is the SEC getting involved in admissions with this climate change? And I'm not a fan of it. I've not hidden that. For the last 3 days, I've been preaching from the highest rock. We can't afford the direction we're going. We cannot afford everything we're doing in this. Now you have brought your very important group into this admission, asking questions for whom? 10,000 people that wrote in? Maybe? You said 10,000? How many people do you represent? 354 million, you said? So can I find out what kind of coffee they're making?
It really comes down to this, and it's a good question, and Representative Cloud and Hinson asked really good questions too.
Yeah.
It's a much narrower remit. We're not merit-based. It's not about what type of coffee you drink.
Yeah.
It's that investors today around the globe, thinking about the value of those investments that they make, are taking into consideration climate risk. And companies today are already making disclosures. Now, you could say, well, we shouldn't be involved, but there are already hundreds of companies making disclosures about their greenhouse gas emissions.
And that's their personal choice to do that. I'm not arguing. I'm talking about your rules and your regulations that you're enforcing.
So our role is to ensure that those disclosures, to the extent there's this concept of materiality as well, but those disclosures that investors are getting are not misleading those investors, and that those investors are getting full, fair, and truthful disclosures.
Yeah, I really question your motive there. I'm sorry, I'm gonna have to push back on that one. Let me ask you this then. Recently, you said the Scope 3 emissions regulations aren't well developed. I believe you then said you didn't want to get ahead of the process when you were asked about getting rid of these regulations. Can you quickly tell me if they are planning to get rid of this Scope 3 regulations?
Again, I don't want to prejudge. I'm a member of a 5-member commission. It's how we all deliberate and what staff recommendations
What's your
come
personal
up.
opinion?
But in terms of the comments that we've received, there's a handful of areas. They're well known. All these comments are public, but this area of greenhouse gas emissions of a company, Scope 1 and Scope 2 is their electricity purchases. There was much more support in the comment file, both from investors and issuers, than there was for so-called Scope 3, which relates to the supply chain. And it's not as well developed. I said this a year and a half ago. We took a layered approach. Even in their proposal, we said that that would only be done by fewer companies and have a big sort of a safe harbor, but we're considering what to do there
When you
because
gonna have
we
when
really
you
did
gonna have
get a
an
lot
answer
of
on this?
comments about
I'm sorry, I'm
this.
running out of time. When you going to have an answer on that? A yes or no?
I don't want to prejudge. Staff is working through.
right.
We've never had a comment file as big as this. On average, it takes us 12 to 15 months from a proposal to when we finish
Yeah,
the
you know,
rule.
the idea of forcing these companies to figure out how much they calculated in their disclosure carbon emissions produced by themselves, as well as all their vendors, partners, and suppliers, is about as anti-business as I've heard in a long time. And given your background, you think you'd be a little more business friendly. You know, that, quite honestly, that it goes against everything that your bio that I actually read, because this is very, very unbusiness friendly. And we're in the business to help and assist companies to produce jobs, to produce a product, to stimulate this environment so it creates taxes, so it pays bills to keep the air conditioner on in this room. So why do we want to just, and I'm out of time, but I'll make this last statement. Why don't we want to just keep sticking it to the businesses and just keep piling on regulations when all we need to do is leave them alone? There's enough people checking their admission. We don't need the SEC doing the same thing.
I concur with you. That's not our role. Our role is
Then
just
why
to
do we
help.
do it?
So it's those raising money from the public, those companies raising money from the public are currently making disclosures, and it's trying to make a consistency. It's also trying to sort of tamp down greenwashing, if you've heard that phrase as well. It's trying to bring some consistency to those disclosures, and also based upon the comments that are coming in to sort through. But we literally have hundreds of public companies that are supportive of pieces of this rule, and they say, no, over here,
They're
could you
supportive,
adjust
sir,
this?
because they know they're getting pressure on them to do this. That's the reason they're doing it. They don't want any more regulations either. So, Mr. Chairman, I return my time. Thank you.
Ms. Torres.
Mr. Chairman, can I have 1 second?
Ms. Torres, if you would pause for just a moment. Now, I'll yield to the ranking member.
I thank you. I want to get this straight. What the SEC is to do is to make sure the representations being made by those sellers of assets or companies trying to raise capital are accurate. That's your role.
Absolutely, full, fair, and truthful.
What you are saying is that 800, 900, 1,000 companies have chosen to make a representation based upon climate or other factors. That you have not required that. Now, there was statute, as that Mr. Cloud, I believe, pointed out, that failed, but you have not required that. But what I understand you're saying is, once that a company makes a representation, it is your responsibility to make sure that that representation is accurate and true. Is that what you're saying?
That is accurate, but it goes further than that because we put out a proposal that would, in many of the disclosures are exactly what you say, but we did put out something that if it was, for instance, this scope 3 that we were talking about, our proposal, we don't know where we'll end up, but if it was material to the, in essence, to the business, if it was material to the investors, that you had some mandatory disclosure. And I think that's probably part of this
I understand.
discussion.
Okay. Thank you, Mr. Chairman.
Ms. Torres.
Thank you, Chairman, and thank you for allowing this flow of information to continue even though we are literally under the clock. Thank you for coming to our subcommittee, Chair Gensler. You know, I understand that my colleagues disagree with your work on climate disclosures. My region, the state that I come from, is home to 40 million people. We know that climate change is leading to an increase in devastating fires, major floods with this rain storms that we've had, tornado warnings. We don't know what a tornado is in California. We know all about earthquakes, but not about tornadoes. In most cases, well, in all cases, as property owners are trying to renew their fire insurance to fulfill the commitment that they have made to the bank when they applied for a mortgage loan. In the last 5 years, our mortgages, our fire insurance has doubled in some years and has gone up at least 10 to 20% in other years. It is incredible what is happening. If my point is that corporate America knows that climate change is real, contrary to what some of us may want to believe. They are making real business decisions that impact the people that I represent. We must ensure that communities like mine are getting the information that they need in order to make financial decisions in light of climate change. So I urge you to continue to provide this information because it is critical, at the very least, for the 40 million people in my home state of California. I want to go back to the issues with Silicon Valley Bank. Can you update us on, I know that you are in the midst of an investigation, but will there be an after action report to find any lessons learned and implement them moving forward as to what you can do? What more can you do to ensure that we try to avoid another chaotic event?
Though I can't speak to any particular investigation or any
I'm not
possible
asking
enforcement.
that. Yeah.
But when market events occur, sort of the playbook, if you wish, what we look at is what are the disclosures companies have made? We've had a lot of discussion about disclosures, but were they truthful? Were they accurate and full and fair? We look at to the extent we can, was there any inside trading material, non-public information? We look at whether there was any market manipulation. These are the things that we look at in our enforcement regime. And we also look at more broadly are there lessons learned to help make the system more resilient? There's always risk in capital markets. That's part of the dynamism of capitalism. But it's also ensuring that those risks don't spill out to regular folks, And let's just not forget that in 2008, 8 to 10 million people lost their jobs. So part of an agency like ours is to try to look at lessons learned as their resiliency in the capital markets around broker-dealers and asset managers and the like.
In 2009, that many more people lost their homes to foreclosure because of, terrible bank investments that they were investing against, the people that they were mortgaging. So with the cuts, I know that you oversee so many programs. You have had, numerous comments online, more than you've ever had over the last 5 years. What will a 30% cut across the board do to you?
I hope we're not talking about that, Congresswoman.
We have to talk about that because it is on the table as it relates to the majority's proposal.
Look, I think the investing public would be shortchanged, and the capital formation. The companies that want to do right by their investors and raise money, that the investing public wouldn't have as much trust in those capital markets. I think that what we do as an agency on a day-to-day basis is responsive to the world's gold standard of capital markets.
Thank you, and I yield back.
Mr. Subcommittee.
Thank you, Mr. Chairman, and thank you, Chair Gensler, for coming before the committee today. As the new guy in this table, I'm gonna, after listening to my colleagues here discuss really the scope and the depth of the SEC's rulemaking authority, I'm gonna start a little broader just to get a better understanding of some questions that I have. Would you mind outlining for the subcommittee how much funding goes towards the activities related to each individual part of the SEC's core mission of protecting investors, free markets, and capital formation? And additionally, how many FTEs are associated with each one of those missions?
It's a good question. They're so intertwined. I mean, we promote capital formation by also protecting investors. We promote both by having the markets in the middle more competitive, more transparent. So we don't keep our books and records and separate out the three missions because they complement each other, especially I think of the first two, the capital formation investors or investors in capital formation. Those, and so we don't. I like your question, but we don't keep our books that way because they're so intertwined, really.
So a follow up on that. On the spending then, so how much of the budget for the SEC on the request and the increase requested is dedicated to enforcement and examinations?
So a little over half our staff is enforcement and examination, and well in excess of half of the growth. I'm just thinking of the 170 more folks, I think about 100 come from exams, enforcement, technology to support that. But if I'm off, we should come back to you.
Yeah, I would love to get some details on that, and even if it can get a little muddy on my first question regarding a range of where the resources are being put. When I look at those three core missions, I would help me get an idea of where the majority of the efforts are going towards, especially if half the staff or more is going towards the enforcement side and the examinations. In your fiscal year 2024 budget request, the SEC is asking for elevated FTE levels seemingly across the board. And can you please outline again, in the same vein of my questioning, which divisions will see the largest growth of FTEs and why?
The largest growth, which I think was actually we put a little chart in the document, but let me just reference it so I'm not mistaken. But the largest growth was, again, it's in enforcement and in exams, but third would probably be, just want to make sure, it's actually the Division of Economic Risk Analysis is probably third. Mm-hmm. No, I apologize. Our Division of Corporate Finance that reviews the filings of public companies is third, and then the Division of Economic Risk Analysis.
Thank you. I have about a minute and a half left. I'll ask you one more question. We had Secretary Yellen here before the subcommittee last week, and I asked about how the system of as a whole is reacting to Silicon Valley Bank. And so Chair Gensler, as a voting member of the Financial Stability Oversight Council, did the SEC identify warning signs regarding the banks that recently experienced trouble when it came to rising interest rates? And why or why not?
So the Financial Stability Oversight Council, in its 22 annual report, so late last year, identified interest rate risk as an important risk in the financial system and within banks. There was a whole section in the report. And when interest rates rise, the value of securities and loans can fall. And so that puts pressure on the people holding those debt securities. And so it was identified, as I say, late in 2022 in our annual report.
Mr. Chair, I yield back. Thank you.
Mr. Joyce.
Thank you, Chair. Chair Gensler, it's nice to see you again.
Good to see you, sir.
I could tell from the questions of my colleagues that this ESG question is still out there and remains ready to ripen. But I want to ask you, do you support the double materiality standard which has been adopted by the Europeans in their corporate sustainability reporting directive?
Congress's mandate to us is about investors, and it's really about just what is material to an investor making an investment decision, and those decisions are buying or selling or voting a proxy, and that's our remit, and it doesn't go further, and that's all we're looking at. So that's what some people would call single materiality.
Well, the Europeans now believe that not only material risks should be disclosed by public firms, but also risks posed by the firm's operations to society and the environment should be disclosed. What kind of information, if any, that progressive ESG advocates demand from public companies do you believe may not fit within the materiality standard or constitute a real risk?
Well, it's really about what investors, and we've heard from a remarkable number of investors about they're looking at as climate risk in terms of their investment decision, and that's the extent of our remit, which is different, as you said, than in Europe, and it's really about what climate risk might mean to their revenues, their profits, their suppliers, their competitors, what legislative bodies around the world, not just here in the U.S., might do to change their business and requirements. So that's what investors have told us. It's really about what's going to be the effect on the future financials and operations and competitive landscape and supply side of these businesses.
Well, the Appropriation Committee is serious about ensuring funds provided the SEC will be used to carry out the agency's mission as directed by Congress. Last year, we had some discussion on the request for funding that you had with cryptocurrency. I guess that didn't go so well, but I'm concerned that the high volume of new rulemaking has prevented the SEC from fulfilling its basic due diligence obligations. For example, the agency's proposed rule requiring increased cybersecurity disclosures does not consider existing requirements established by Congress and agencies that specialize in cybersecurity, like CISA. As the chairman of the Homeland Security Appropriations Subcommittee, I'm concerned that public reporting on cyber practice will provide a roadmap for bad actors. Investors won't be protected by this rule if the firms they invest in are harmed. Are you working with CISA to ensure the SEC's required disclosures don't reveal sensitive information to cyber criminals?
We've had a good dialogue with Jen Easterly and her team. She's the head of CISA.
Oh, I know. She was in before our committee just this week, so that's why.
And our remit, again, and we had this discussion about climate, it's really just investors making investment decisions. So if a cyber incident happened at a company and hypothetically tens of millions of client files have been stolen or hacked or something, is that material to the company sort of in a sense like a factory were to burn down, but instead 100 million files are taken or something. Is that material? And then investors getting that information. We did put a proposal out, but it's a proposal about summary information. It's the information that would be material to investors, not the details of how the breach happened or so forth.
But in order to accumulate that, they're going to have to create a document that somehow a bad actor may find, correct?
Well, they also have to sort of accumulate it for their board of directors and discuss it with their board of directors. And if they're discussing it with their senior leadership and their board, then to let their owners, the owners of the company, the investors, understand if, and our proposal was about material incidents.
I understand. I understand I only have 40 seconds left or now in decreasing. But I just want to follow up, too, on what they were talking about, the small business. You and I had this exchange last year, and you said it was only the publicly held companies. Yet, in some of the comments I received from NFIB indicate that they're still concerned that somehow this is going to affect the small businesses, or as my colleague brought up, the farmers and other ones. Have you worked on trying to make sure they're precluded from that requirement? Because obviously they're not, they don't have the law firms and the people necessary to report this on a daily basis.
Again, without prejudging what staff recommendations will be or my fellow commissioners, I think that this has been an important exchange here today, but also with the American public has weighed in as to we oversee the disclosures of these 7,000 or so public companies, not other companies that are not. And so sorting through some of these comments is part of what the staff is thinking through.
But again, that would eliminate the mom and pops who are doing business with those publicly held companies because they fall in that same chain. But I'm out of time, and I'll give you the 30 seconds extra that I took out. Thank you.
Thank you, gentlemen. We're going to do a quick round two. I know Cindy's group, for the most part, is left, but we've got several of our members remaining. Let me go back. I'm going to close out my last question on the academics, and I got your answer, and I understand that, but you know, academics that want to serve, that's a noble thing, and I'm grateful for that, but I certainly would think that we should be incorporating academics that have some real-world experience. That would be my ultimate goal, were I sitting in your seat. I want to follow up on what Mr. Joyce was just talking about, Scope 3 notwithstanding. The SEC does an evaluation, an economic analysis of rulemaking procedures. Do the down-the-chain costs, are they considered? I mean, there are, particularly as it relates to the climate rule, this has a potential significant effect on small and medium-sized businesses that are part of that whole supply chain. And in my opinion, these costs are large and may not have had the opportunity to comment. So your response to that?
If I can, with your permission, the heads of our divisions of investment management, trading and markets, and corporate finance have served their public well, but also have real-world experience. The heads of investment management and corporate finance are leading lawyers. Yes, they were at academia, but they were also, one of them was at a big law firm before he was in academia. I mean, they really are true experts on investment law and on corporate finance disclosure law. Our head of trading and markets is one of the leading people on what's called micro market structure, but thinking about and really understanding how the details of a market work. And what we're trying to do on our treasury market reforms and equity market reforms and the like are so incumbent to, again, promote capital formation and investors by trying to get more efficiency in the middle for the investing public. So again, sir, I think they have very real-world economic experience. We're often told at the SEC to do our economics right, to have a world-class economist heading our Division of Economic Risk Analysis and Trading and Markets.
All right,
I like going into battle
let's
with
move to
these
the impact
folks.
on small business.
So on small business, again, in the discussion, we look at the impact on small business across all our rule writing, but in terms of this climate disclosure, again, we're looking at that because it's really about, our remit's just about those companies that are publicly filing, publicly raising money, and their climate risk disclosures.
We've got a very diversified economy. We got a $20 trillion plus economy. These disclosures, and you mentioned the consistent, across this diversified economy. These disclosures are different from company to company, are they not?
They can be, because some companies are in different sectors and so forth.
Well, I guess my question then would be, don't the companies know a lot more about their risks than a government agency like the SEC? I mean, would that not be the case?
What we lay out is rules, and we have for decades, like on material risk. We laid a rule out in the 1970s to disclose your material risks. We also, in the 1970s, laid out rules about environmental disclosures. What's come along is investors now are getting a lot of disclosures about climate risk, and as we were chatting with Representative Hoyer, that they're already making these disclosures, and trying to bring consistency to that helps investors make their decisions, and it also helps the companies as well to have some consistency.
I just guess my point is that in your search for consistency, that the SEC is becoming judge and jury over which risks are important and which risks are not, and that's the basis of my argument. And I'm going to, if my team will indulge me here for a minute, I wanted to, let me just do my data security and CAT question. I'll submit for the record because I am out of time, and I want to be fair to all of the other members. I want to be fair to you too with your time. Thank you so much, and I'll yield back to the ranking member.
I continue to struggle about the chicken and the egg here. But I'll pursue that later because I'm not sure I have as deep an understanding, because it could well be a problem. On the other hand, the persons who determine whether or not there is a risk or that they are willing to take are the investors, based upon the information that is disclosed, which you have the responsibility to make sure is accurate information. Now, I understand there's a process underway in which there would be a more active, positive, or some would say not positive, step that the SEC would be taking to require certain disclosures on energy or climate or actions. Am I accurate so far?
That's correct, and also there was a part of it that we proposed that it be put in the annual reports rather than just on your websites and other reports.
Okay. So the concern is that we're making that a requirement. And as I understand the concerns being raised by some of my colleagues is that is beyond the scope of your authority to do.
Well, we think it's let me say, we think it is within our authority. We've had mandatory disclosures about material risks to the business since the 1970s. We've had mandatory disclosures about management discussion and analysis since going back again 50 to 60 years. We've had mandatory disclosures about other environmental issues going back 50 years. So we do think that it's within our authority. But in this space, in this climate risk disclosure, most of what we've done, not all of it, is about if you make a disclosure, for instance, about your scenario plan, or if you make a disclosure about your targets.
Let me stop you there.
Make it accurate.
The implication of if you make is that the company makes a determination whether or not they want to make such a disclosure, clearly with the interest of encouraging greater investment. Your role at that point in time is assuring that that is accurate information that's being put forward.
Yes, or not material misleading in the words of the statute, but there are parts of it that we proposed were mandatory, particularly around what's called Scope 1 and Scope 2 greenhouse gas. And then in Scope 3, we took a narrower remit and just said it was if material.
All right, I'm gonna look into that further, because I want to understand my colleagues' real concern to see whether I share their view that it may have effect on small enterprises which do not have the ability to respond to that, or may be implicated by association, if you will.
If I can help the member out, most of those comments by your colleagues and from the investing public is around what is called so-called Scope 3, the suppliers and customers of a business, and what are their greenhouse gas emissions. And that discussion is an ongoing one by the staff and the commissioners at the SEC, because we did get a lot of feedback on that.
So that is not a resolved question at this point in time.
It was proposed, but you're right, nothing's resolved really in a proposal, adoptions or, when that happens.
Last question, which I know is not your direct responsibility, but I'm interested in your thoughts on it. To what extent did the reduction in the level of capital reserves that was passed under the last administration, in your opinion, did it have on the failure of the SBB bank, SBB?
I'm sorry, sir, are you talking about the law that was passed in 2018?
2018, yes. To what effect, if any, do you think that had on the failure?
I think it'd be better for me to leave some of those questions to the banking regulators. I know they're going to be reporting come May on that. It's probably a matter of public record that I was not supportive of that legislative initiative back in 2018.
Why?
I thought at the time, and I have to remember the letter I wrote, but I thought at the time that there was a risk of correlation, that even these banks that are in this, I think it was raising the limit from 50 billion to a higher number, but that these banks, that there could be a correlation in the market. There was also some provisions about custodial banks and foreign banks, as I recall, that I raised some questions about.
I'll pursue that further. Thank you, Mr. Chairman.
Mr. Molinar.
Thank you, Mr. Chairman, and thank you for your time. You've been very generous with your time. I'm trying to get a better understanding of kind of how you view this role. The way I hear you, it's almost like you feel that you're providing a service to the businesses, the public companies, service to the investors, I should say, by vetting whether the company's statements on climate are accurate, and you view that as a key role for the agency.
I think Congress set us up that key role is that disclosures are there about the financials, the description of the business, as I say, over the decades, key risk, and investors really get to decide what they think is material. And over the last 10 years, investors more and more have been looking for, and companies are making these disclosures.
No, I get it. There are activists, investors with a political agenda. That's clear. And they want certain types of information. But what I hear you saying is this federal agency really has the job of vetting to see whether those agendas are being carried out, is really what I hear you saying. Almost, and I'll contrast it, because when I hear of a billionaire flying a private jet to Davos to talk about climate risks, and then going off to the Super Bowl and Hollywood parties and saying they've been able to offset their credits doing some other project that they're involved in, I think that person is being hypocritical, but I don't think they're breaking any laws. And what I view a federal agency like the SEC would be, you'd be responsible for making sure people aren't breaking laws, not the fact that they're being hypocrites. And so that's where I want to understand really what your philosophy is when it comes to evaluating climate as part of your role of an agency.
It's far narrower than the word that you chose. It's not about vetting. It's about two things. We had this discussion. It's ensuring that those disclosures being made, particularly the material disclosures, are not misleading the public. They're full, fair, and accurate. And there's also a part of our responsibility that on certain disclosures that they be made, they be required, like the financials, like the executive compensation, things like that.
Okay, but in the case of sort of the disclosures, why not have a private entity like Standard & Poor's or Moody's or someone who can look at all the stuff these companies are saying to appeal to a certain agenda, and let them do that, and you stay in the business of the regulation and, preventing fraud, which in my mind, when you say, the SEC's been involved with, when it comes to environmental liabilities, let's say there's a major cleanup that a company has to have, or a consent decree that they're part of with the EPA that's going to cause them financial risk. I get why you would evaluate that. But when it comes to them putting stuff on their website and saying they're following all these sort of social norms, why in the world would you want to expend valuable resources for your agency being in that role?
It's really to protect the public that there's not materially misleading disclosures, and it's also to promote the capital formation that investors get something consistent and they can make comparative. There's a comparison between these investment choices.
But if I'm an investor in a company like that, can't I hire someone to give me advice on, okay, this company's doing what they say they're going to do, this company isn't? Why is it the SEC's role?
I think Congress decided many decades ago that it is our role because it's a role to help promote capital formation in this country and promoting it by having a federal agency like ours to help bring some consistency. And some of that consistency is well established, of course, like generally accepting accounting principles and how you book revenues. And some is more emerging in these last dozen years that there's a lot of disclosures around climate risk and how to help bring some consistency, but it's merit neutral.
Well, I do feel like when the administration wanted to create this disinformation governance board, you remember when the administration wanted to do that through Homeland Security? It feels very much like this, like you're putting yourself in this role of evaluating the claims of these businesses and really outside of your jurisdiction.
It's really up to the investors to evaluate. It's our role just to help bring some, as I say, truthfulness in advertising, if you wish, and yes, some requirements on material disclosures.
Thank you. Thank you, Mr. Chairman.
Ms. Hinson.
Thank you, Mr. Chairman. And just to follow up on that briefly, I think it is very clear that with Mr. Cloud's comments that Congress felt the need to pass something in the 117th Congress to clarify the position that it wanted to give you the authority, which again, I would argue you don't have, and we can disagree on that, but I think that congressional intent could not be clearer there. I do want to go back to something, though, that since we've had such a conversation today about the rulemaking process, under Democrat and Republican administrations, we've seen the public comment periods be historically 90 to 120 days, 3 to 4 months for those public comment periods, but all of yours, almost all of yours, I should say almost all, have been dropped to 30 days. Why?
Actually, on average, from the time we vote on our proposals and put them on our websites, we've averaged 78 days.
But for public comment, that narrow time when you're accepting those 30 days, correct?
Now, we accept comments throughout a period of time. When it goes in the Federal Register, it takes some time to get in the Federal Register.
Right, but you're saying average, right? Average of 78 days, but that includes the ones that are longer. So when I'm looking at the intent behind dropping most of them to 30 days, to me that's a transparency problem. To me, it says that you want to limit the number of viewpoints that are coming in by limiting it to 30 days. So that's highly concerning. I'm hearing a lot about that from a lot of folks, let's say, about how much time they have to actually formulate and get their opinions in. We talk about that climate rule. Making sure that there's enough time for feedback on both sides of an issue, I think, is very, very important. I want to also go back to the Inspector General's report for just a moment. Have any SEC managers expressed any concerns to you that with the reduced comment time in some of these cases that they are having trouble getting data from all stakeholders?
I want to assure the members too, we get comments even after the comment period. We take meetings. Even this discussion today is part of our administrative record on a number of rules, like the climate rule, and we consider that a five-member commission. So that's just the nature of these things. We have a end of a comment period, but we also often receive and consider comments well beyond this.
So even though the deadline may have passed, you're still actively considering the feedback that you're getting in?
Yes.
Is that fair to say? I think it's concerning, though, when in the report it shows that staff do have concerns here on page 3, that they have not received as much feedback during the rulemaking process, either as a result of shortened timelines during the drafting process or because of shortened public comment periods. So I think that is concerning when we're seeing that in the IG's report directly. There's a direct line there between a shortened comment period and this feedback in the report. Would you agree?
I think there's a sentence in the document that says that.
So, yeah, directly connected. So that's where my concern is specifically with the timing there. As far as recommendations from the IG, how many of them are withstanding? How many have been resolved?
We work with the Inspector General's office to resolve comments. Most of, if I recall, were about human resources and hiring. And we go through that process with them. We'd have to get back to you to tell you.
I would appreciate within I think we're asking for about 15 business days. If you would get those back to me within the next couple of weeks, I would certainly appreciate that.
You got that.
Thank you. I yield back.
Mr. Cloud.
Thank you. Chair, you continue to kind of say over and over that, okay, these businesses, they're already producing these, reports, and therefore, but there's a difference between a company who voluntarily is doing something of their own initiative because they want to, and the strong arm of the federal government coming in and requiring it for every business because there's a few businesses that want it. Can you not acknowledge that there's a big difference in that?
As we've discussed, there's attributes of our disclosure regime for decades that are mandatory and we require. There's some that
Your
are.
proposed rule requires businesses to do this. Not only requires businesses to report, it requires them to report on their entire supply chain and their supply chain in a sense. And it really, to anyone looking at this, really seems, as I think it was Mr. Molinar was saying, really cognizant of a lot of the things we're saying. And you said that your main job is basically to see if they're accurate and true. Is that right?
It's to bring efficiency, as Congress's words, is also to bring efficiency, competition, and capital formation. And so
I mean, your job is to make sure that these climate reports are true. Are you planning to hire a bunch of scientists, or, how do you plan to go about that?
The same way we do on other disclosures. It's really to set in place a set of rules, if we were to adopt this, but to set in place a set of rules, and then issuers follow the rules and investors get to make their investment choices.
The other regulations that you talk about that you require reporting on, things like executive salary or, capital that's available and those kind of things, those are all internal metrics that have to do with, the financial stability of a company. To have climate regulations is something, it's a whole different thing. And you're comparing apples and oranges here and pretending they're the same thing, but they're not at all. It's kind of a bizarre approach. There's been values-based investing for a long time. I mean, people can look at companies and decide whether or not, but for the federal government to come in and decide that these are the particular values that we want to force reporting on, I think is very, very troubling. I mean, I'm very concerned about human trafficking and slavery, and a number of the Green New Deal energy sources are mined with child labor in countries throughout Africa, the Congo, for example, and solar panels, a lot of them are built with slave labor in China. Are you planning on requiring reporting on that as well?
Again, this is driven by investors currently are making investment decisions based upon climate risk.
But that
of the
doesn't change your
issuers.
mandate at all. If every business in the country came to you and said, we want this, it doesn't change your mandate at all, does it? Until Congress acts.
No,
You don't have any new authorities because 100 businesses, as you said, want this, want new regulations.
I believe, and our lawyers believe, it's within the mandate Congress has already granted us.
Have you considered that a number of businesses actually like regulation because it creates an uncompetitive environment, particularly large companies that can afford lawyers and the likes to create these reports, and they are much more able to compete in that environment, and it squashes the competition of it helps create the wealth gap. And have you considered that into your consideration on whether to promote these rules or not?
We do consider promoting competition for small business as well as competition among all the issuers as well.
I only have a minute left, so I wanted to touch on this while we can. It's a different topic, and that is there was a mention about people in Congress stock trading. That's certainly a concern that's worth looking into. One thing that's completely overlooked that there's no transparency on, I have an act it's called the Divest Act, is to look into agency heads at a certain level and up who are investing in stocks in areas that they're regulating as well. Are you familiar with the Wall Street Journal report that came out in, I think it was last year, August of 22, that touched on this?
I'm generally familiar that there was some reporting, I don't recall which paper, about investing.
It highlights 25% of federal officials who filed public financial disclosures at the SEC were investing in stocks of firms that were lobbying that very agency. And so is that a concern that you are looking into, and would you work with me and maybe even perhaps support legislation like the Divest Act that would make sure that regulators are not investing in the areas that they're overseeing and regulating?
So, yes, we would work with you on technical assistance on any, and this is true of any member, but we'd work with you on it. In terms of the SEC, just in terms of the SEC, we have some of the highest level of restrictions on any trading, partly because of the nature of who we are and so forth, and we work with the Office of Government Ethics. For instance, none of our employees can invest in the sort of the individual, the broker-dealers, investment advisors that we oversee and so forth, or any of the companies that we might be investigating and so forth. There's a lot of restrictions. At my level, it's not even allowed to, the commissioners. We don't even invest in any individual stocks. It's just the broad-based indexes.
Mr. Joyce.
Thank you, Chair. Chair Gensler, how has the huge number of proposed rulemakings at your agency impacted the quality of these rules and your ability to effectively consider comments submitted?
I think that the quality is quite strong, and again, what we're doing is fairly consistent with what my predecessors have done.
Do you think this has affected your attrition rates?
I think that the attrition rate is driven by a tight labor market, really talented staff that are taken, but it's also consistent with other federal agencies at this roughly 6% level.
As you know, the markets certainly don't like uncertainty. Are you concerned that so many transformative new rules likely to be litigated for years and massive swings in policy at the SEC will create uncertainty for many years to come?
I think of our agenda as helping the American public, whether they be issuers or investors, for many years to come.
Okay. Well, under your new collective bargaining agreement with the SEC employee union, I understand most employees will only be required to be in the office 4 days per month. How do you expect to effectively consider comments and perform adequate analysis on over 50 proposed rules with a workforce that barely comes into the office?
The workforce is fully engaged, and I think we've all learned something over these 3 years. We did 3,000 examinations in fiscal '22. We did 760 enforcement actions. We reviewed thousands of companies' filings, and largely through telework. I'm old enough to think, this is new technologies adapting, and people find different work-life balances.
Well, I think the best work that we do is when we're actually together on the floor and have the ability to interact with each other, but I'll take your word for it. I'm give you back the remainder of my time, sir.
For the good of the order, Mr. Hoyer.
Say, I think we're about at an end, Mr. Chairman.
We are, indeed. And with that, I want to thank the members, both our friend's side and on our side. Very, very good hearing. I want to remind our members that they have 7 days to submit questions for the record with the appropriate subcommittee staff. Chair Gensler, as I said in my opening, it's a very important conversation we're having today. You've got a very important job in this country. We thank you for the time that you've given us today. We look forward to working with you as we complete the FY24 FSGG appropriations process.
And I look forward to working with you, and the conversation was helpful for me as well. Thank you.
With that, this subcommittee stands adjourned.
And a good time was had by all.